Section 22 of Tribal Custom in Anglo-Saxon Law. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. Chapter 8. The Tribal Customs of the Oldest Scandinavian Laws. Part 4. 5. The Lex Scania Antiqua. The Lex Scania Antiqua might perhaps be selected as fairly typical of Danish ancient custom, as the Gulating has been taken as typical of Norse custom. But apart from this, it contains some chapters which seem to throw further light on odal and family holding, and so can hardly be overlooked in this inquiry. There are two versions of the Scanian law, one in Latin and the other in Old Danish. They differ considerably and are certainly not translations one of the other, though an older text may have been the foundation of them both. They both refer to recently made modifications of local custom, which fix their date to the early years of the 13th century. The author of the Latin text was the Archbishop of Lund, Anno Domini 1206 to 1215, and from the use made by him of legal terms borrowed more or less from Roman law, it may be gathered that Scanian custom required for him more explanation than the Danish writer deemed it necessary to give. The rules with regard to vergelds cannot be quoted as representing unmodified ancient custom. They avowedly are the result of modifications made to remedy evils, which had arisen partly, no doubt, from the gradual loosening of the ties of kindred. In the same way, the clauses as to property represent the results of long-continued conflict between ancient rules of family holding and gradual innovations in the direction of individual ownership. In this they resemble the lex salica. Still, if family holdings, more or less on the lines of the cumric guelu or the salic allod, had once been the prevalent form of occupation, even new rules making alterations could hardly fail to reveal traces of older custom. The special value to this inquiry of the Lex Scania Antiqua is that it does so. Disguised as some of these traces may be in the Latin text, under Roman phraseology, with the Danish version at hand, it ought not to be difficult to recognize the meaning of the facts disclosed. The first chapter relates to the rights of a wife surviving her husband when there are no children of the marriage. Quote, Omnia, quae in hereditate sunt mobilia, vel se moventia, vel immobilia, precio tempore matrimonii comparata, equis sunt partibus dividenda, medietate heredes defuncti proximus cum predies, que propria ipsius fuerant, et uxorum altera cum suis predies contingenti. All things in the hereditas which are movable or cattle or immovable, brought in by value, fixed at the time of the marriage, are to be divided in equal parts, one part appertaining to the next heirs of the deceased husband, with the lands which were his own, and the other part to the wife, together with her lands. End quote. This clause may very possibly represent an extension of the rights of a childless widow beyond what tribal custom may have originally given her, but certainly the fact that under Scanian law the childless widow was entitled to half of what by compact at the time of the marriage had become the joint property of husband and wife, while the other half went to the husband's next heirs, is good evidence that marriage was by no means a surrender of the wife and her property once for all into the power of the husband and his family, and evidence of the accord of Scandinavian with other tribal custom on this point is not without value. It may be observed, however, that in the case mentioned, there had been something like a compact or valuation of the property brought under the marriage arrangement at the time of the marriage. The result might therefore have been different if no special compact had been made. The inference might well be that the childless widow in that case would not have been allowed to take her half-share with her, away from her husband's kindred. Chapter 3 refers again to a wife's property, and adds important information. It brings before us a family group with something like a family holding, and it becomes intelligible only, I think, when approached from this point of view. Into this family group a wife has been brought, apparently, without the special definition or arrangement. There are also children of the marriage, and the question asked in the heading of the Latin text is, what shares the grandchildren take on their father's death, not in their parents' property, but in the property of the grandfather. The grandfather is the head of the family group. In the Latin version, he is elsewhere styled the pater familias, and in this clause his sons are filii familias. In the Danish version, the family group is simply that of an ordinary bonde, and the family character of the holding is taken for granted as not needing special mention or explanation. The chapter is as follows, divided into sections for convenience in comparison of the Latin and Danish texts. Quote, De bonis avites que portio contingat nepotes post obitum filii familias. Unus. Filii familias in sacris paternis cum uxore constituti, si sine definitione certe quantitates bones patris addiderit bona, que ipse habituit cum uxore quodcumque fuerint filii de communi substantia, etiam prediorum post contractas nuptias comparatorum cum avo et aliis consortibus post obitum patris viriles et equales accipiant portiones. 2. Per priorum gradum ab alis predis excludendi. 3. Si vero in mansione patris bona que abuit cum uxore fuerunt definita illa sola, si viventi avo pater obierit filii quodcumque fuerint obtinebunt. Of the grandfather's property, what portion goes to the grandchildren on the death of a filius familias? 1. If a filius familias established with his wife in the paternal rights shall, without definition of the exact quantity, have added to property of his father, property which he himself had with his wife, then however many sons there may be, they shall, after the death of their father, receive equal shares per capita with the grandfather and co-sharers in the common substance, even of lands acquired after the marriage was contracted. 2. They having to be excluded from other lands by the prior grade. 3. But if in the mansio of his father the property which he had with his wife had been defined, that alone, if the grandfather was alive when the father died, shall go to the sons, however many they may be. End quote. The Danish text, 1.5, is as follows, quote, bonde sun fuera conocina hibo moet feiser sinum, in farbonde sun conu ok forerane hibo meit fasor sinum, ok öfler barn vither hana ok legs, I felig dere emailin sador bondan sun. Taki all hans bön fulan lot efter dere father eim vel I kuppe iors som I wolfe. 2. Ein af hans faderins jorso fade ei, vate mer ein han wil ge dem. 3. Leefs velach dafa te ei mer ein han atta ich bo. If a bonde's son brings his wife into the house with his father. 1. If a bonde's son gets a wife and brings her into the house with his father and begets a child with her, and no partnership is made between them, if the bonde's son dies, then all his children take a full lot after their father as well in land purchased as in movables. 2. But of the bonde's father's lands, they get not a whit more than he will give them. 3. If partnership is made, then take they no more than he, their father, owned in the house. End quote. This clause in both the Latin and the Danish version confirms the inference from the previous ones that there was a difference of destination as to the property of husband and wife, according to whether it had or had not been defined and so put in partnership as joint property of the husband and wife separately from the property of the family group represented by the grandfather. If not so defined, it became apparently under ancient custom part of the common family property, and so divisible after the grandfather's death among all the consortes, instead of going solely to the children of the marriage. The clause pictures for us the family group as bound together by paternal rights, sacris paternis. The grandfather is alive and is the pater familias. A son who is a filius familias, that is, as we shall see presently, not an emancipated son, has married and brought into the mansio, or family homestead of the grandfather, property which he had with his wife. This, not having been defined on marriage so as to keep it separate, has become, in the phrase of the Latin text, added to the property of the grandfather. The husband has died, leaving several sons, it matters not how many. The question is, what share these grandsons are to take in the property which their father had with their mother, which, for want of definition, has become added to the grandfather's property, or in other words, become part of the substantia communis. The answer is that the parents' property does not go exclusively to their children as it would have done if it had been defined in separate property. It has become merged in the family property, and there's no sharing of this till the grandfather's death. But apparently by a compromise, due probably to recent legislation, they are allowed on their father's death, according to the Latin text, to take equal shares in his property per capita with the grandfather and other consortes, or, according to the Danish text, a full lot in it. We are not told who were the consortes with whom and the grandfather it was to be shared. The consortes, whether uncles or cousins or both, were the co-sharers in the communis substantia of the family holding. In the final paragraph of the clause, both texts give the alternative rule applying to cases, probably the most frequent, in which proper definition of the wife's property had been made on the marriage, and the rule is stated to be that the property so defined and made joint or partnership property on the marriage, and that alone, illa sola, would go to the children of the marriage at their father's death during the life of the grandfather. According to the Latin text, they were excluded from the other family property by the prior grade. As the Danish version puts it, not a whit of the other property would they get, except what the grandfather chose to give them. That this is the true meaning of these clauses is confirmed by other chapters. Chapter 16 is headed, How much may be conferred by a father upon the sons of a deceased son during the lives of the other sons, their uncles. The text is as follows, quote, Licet quicque post mortem filii quantum ipsi deberentur, si viveret, eius filio nepoti confere. It is lawful to everyone after the death of a son to confer upon a grandson, the son of that son, whatever would have been due to the son had he lived. End quote. This seems to be a special permission to the grandfather during his life to mitigate the injustice of the customary rule excluding grandchildren from succession by representation in their deceased parents' property. If under Scanian custom the children of a dead filius familias had succeeded by right to their father's property, this special permission would not have been needed. But it seems to be clear that no such right of succession was recognized by ancient custom. Chapter 11 opens with the following general statement, there being in this case no question of a marriage or a wife's property. Quote, Patre superstite defunctus filius familias nullum habet, ac si nunquam fuisset genitus successorum. The father surviving, the dead filius familias, has no successor, as if he had never been born. End quote. This seems to make it clear that the grandfather being alive, the grandchildren took by right under ancient custom no share in their deceased father's property. It was simply merged in the family holding, and they must wait for their shares in it along with the other co-sharers after the grandfather's death. The growing feeling of the injustice of this from the individual point of view was probably the reason not only why the permission in Chapter 16 was given, but also why, following the example of Roman law, the emancipation of sons was admitted. Chapter 11 proceeds, after the initial sentence above quoted, to tell what happened in the case of the death of an emancipated son dying without children, but this does not concern us. It may be well, before passing from the consideration of these clauses of the Scanian law, to bring into notice a short, isolated clause from the Gulating law, which seems to accord with them, and so to connect the Scanian rules of family holdings with somewhat similar rules as to the Norse odal sharing. The denial of the right of representation in both Scanian and Norse ancient custom suggests that a common principle may underlie the custom in both cases. The clause of the Gulating law, 294, is as follows, quote, Nu ero brother, ter och andast, anar fyr en fader, ter och liver, soner efter in dauze. De skal han dan lot lesa åthla at fimtungsfalla, undan fader, broder sinum, sim fader, han stod til efter fader sin, an eigi ma han fir lesa an fader, hans an daser. Now there are 2 brothers, and one of them dies before their father, and a son lives after his death. He shall redeem from his father's brother at 1/5 less that part of the odal to which his father was expectant, heir after his father, but he may not redeem it till his father's father be dead. End quote. In this case, as before, there are living a grandfather and a son, and a grandson, son of a deceased son. The share which the deceased son, as co-heir with his brother, might at first sight be expected to take in the grandfather's odal, does not go directly to the grandson. By apparently a new law, he has permission after the grandfather's death to redeem it from his uncle at 1/5 less than its value. This can only be explained upon the principle that under ancient Norse custom, the sons of a deceased son would not succeed by right of representation to their deceased father's share in the division of the grandfather's property. Evidently, the right to redeem it from their uncle was an innovation of later law. These and other innovations may have been the result of a new sense of justice brought in with Christianity, or under the influence of Roman law. The question for us is the meaning of the ancient custom. And we are brought back to the point that insofar as the family group more or less may have resembled the Cumric Gweli, and is approached from this point of view, it must be regarded as the group of descendants of a common grandfather or great-grandfather, who is, in the Archbishop's phrase, the paterfamilias. While he is alive, the landed rights are vested in him. On his death, his sons take his place with divided or undivided equal shares, but still as the representative members of the original Gweli, or family group. One of them dies, and the question is whether the surviving brothers of the prior grade are to promote into this grade at once the sons of their deceased brother. Such a course might naturally be regarded as preferring these nephews to their own sons. The rights of all the members of the lower grade will come in time when all of the prior grade are gone, and the grandsons share equally per capita in the family property. In the meantime, the sons of deceased parents, like those whose fathers are alive, must wait. So it may have been under ancient custom, but in course of time family ties weaken and individual rights grow stronger in national feeling, as we have seen them everywhere doing, and then little by little compromises are made. The joint property of husband and wife, even if not properly defined, is recognized in the Scanian law as belonging to the sons of the marriage to the very limited extent that they may have equal shares with the other consortes, whether uncles or cousins. The sons of the deceased brother, when the grandfather is dead and division among the brothers comes in question, are allowed by the clause in the Gulating law to buy back their father's share in the odal at 1/5 less than its value instead of sharing in it as family property. So far, the clauses in the Scanian and Gulating laws, considered together, seem to throw light upon the traditional principle on which the rights of the odal sharers of the Norse laws may have been founded. The rules of Cumric custom may not be identical with those of Scandinavian custom, but we seem to recognize very similar tribal principles at the root of them both. Finally, other clauses in the Scanian law may be alluded to as pointing to the common liability of the family group, that is, of the paterfamilias and others in communione with him. Chapter 9 is as follows, quote, Universos contingit de communi consortio quicquid vel culpa amittitur vel industria conquiritur singulorum. As regards the common consortium, whatever is lost by the fault of or acquired by the industry of individuals concerns all. End quote. And in Chapter 87 it is enacted that if a person denies that he is in possession of a thing stolen, and if afterwards upon scrutiny it is found in his house, double the value of the thing stolen is to be taken, not only from the portion of the paterfamilias, but also from the common property, de bonis communibus, however many there may be with the paterfamilias in communione. And the reason stated confirms the prevalence of family holdings of the kind already mentioned. the double value is to be taken. Quote, non de sola patris familias parcioni, sed de bonis communibus, quodcumque fuerint cum patre familias in communione, nam cum omnes lucrum respicerent in detentione non est mirum, si dampnum in ejusdem rei contingat omnibus restitutione. Not from the portion of the paterfamilias alone, but from the common property, however many there may be with the paterfamilias in communione. For since all expect gain from the detention of the thing stolen, it is not strange if all sustain loss in its restitution. The paterfamilias in whose house the stolen property is found is evidently himself a member of a wider family group with common interests and liabilities. And the clause goes on to say that the accused must deny the charge with 12 co-swearers if the thing stolen be worth half a mark, or submit to the test of the ordeal of hot iron. In chapter 99, the ordeal of hot iron is described as having 3 forms. 1, that of walking on 12 red-hot plowshares. 2, that called trux iarn, applied to cases of theft, that is, carrying an iron 12 feet and then throwing it into a basin. 3, that of carrying it 9 paces and then casting it down, called from the throwing scus iarn. After the ordeal, the feet or hands, as the case might be, were to be wrapped in cloth and sealed to prevent fraud, and so to remain till the Sabbath, on which day it should be opened and viewed in order to ascertain the innocence or guilt of the accused. This is one of the causes which fixes the date of the Latin version, for the ordeal was abolished in A.D. 1215. On the whole, we may fairly conclude that the Scanian law, when regarded from a tribal point of view, affords additional evidence of family occupation or ownership, and of the solidarity of the family group in Scandinavian society. But at the same time it shows that in Scandinavia, as elsewhere, family ownership was gradually succumbing to the new rules of individual ownership. The same process of gradual disintegration of tribal usage is visible also in the chapters relating to weergelds. In chapter 43, it is enacted that the amount to be paid for homicide is not to exceed 15 marks of silver. In chapter 44, it is stated that the weergeld is to be divided into 3 equal parts, of which each is commonly called a sal. And in the next chapter, De Compositione, we are told that before the time of the last constitution, it always lay upon the slayer or his heir to provide the first portion only from his own property. He might then exact the second portion from his agnates, and finally the third and last from his cognates. Then it proceeds to say that as excessive amounts were levied by violence upon the kindred, King Canute had laid down certain rules for the payments. Inter alia, it was enacted that of the 2/3 falling on the kindred, both agnates and cognates being computed in their grades of kinship, the prior grade should always pay twice as much as the grades behind it. Further, in chapter 47, it is stated that according to ancient law, the distribution should be so made that each third should be divided again into sub-thirds, one of which should be paid to the heirs of the slain, the second to the agnates, and the third to the cognates. It appears also from chapter 45 of the Latin version and section 84 of the Danish version that special care had been taken to prevent fraud on the part of the slayer in claiming the aid of his kinsmen. He was to pay 1 sal of his own payment before calling upon them for their portion, which was called the oitebot. He then was to collect together his father's friends and compute with them what each was to pay. And when the day for payment came, not a penny was to be paid into the slayer's hands till the hour when he paid it over to the slain man's kindred. Then they were safe. The same course was to be afterwards adopted as regards the payments of maternal relations. The Latin version, chapter 45, proceeds to say that this legislation not having been successful in extirpating fraud and discouraging murder, King Waldemar II, Anno Domini 1202 to 1241, enacted that the murderer should be liable for the whole weergeld instead of 1/3. The agnates and cognates were not to be forced by him to contribute against their will. Within 3 days the murderer was publicly to offer satisfaction or be outlawed, in which case he would be liable to be put to death by anyone. In case, however, of his flight, his relatives, agnates and cognates, were individually to offer their proper share of 2/3 of the Wehrgeld, or be liable to the vengeance of the relatives of the slain, so that the latter should not be deprived of all satisfaction. These clauses throw some light on ancient custom, but they are evident signs of the gradual loosening of the ties of kindred. In chapter 50 of the Latin version, the payment for a servus is fixed at 3 marks, and in chapter 52 the payment for a libertus is fixed at half that of the freeborn man. It is difficult to judge how far these are to be taken as the ancient Wehrgelds of Scanian custom, or whether they had been altered in amount by changes in the currency or recent legislation. The Wehrgeld of 15 marks of silver is exactly half of that of the normal Wehrgeld of the Norse Holt, and yet it does not seem likely that it had been reduced in amount by recent legislation, when it is considered that under the Norse laws, as we've seen, the tendency seemed to be to add sakauka to the ancient Wehrgelds rather than decrease them. It may be noted also that in a later addition to the Danish version, it is stated that a man's bot is 30 good marks, and overbot 26 marks, and 16 ortuks. And also in the city law of A.D. 1300, the Wehrgeld is stated at 30 marks with an additional overbot. We seem bound to consider the Wehrgeld of the freeborn man under the Lex Scania Antiqua of the previous century as 15 marks of silver. The explanation probably may be that the bonde and not the holt was taken as a typical freeborn man, when it is further considered that in the Danish version of the Scanian law there is no mention of the holt, and that, as we have seen, the bonde seems to have been regarded as the ordinary householder, or paterfamilias of the family holding. The inference becomes probably a fair one, that the bonde was the typical ingenuus, or freeborn man, for the purpose of the Wehrgelds. If this may be assumed, then the Wehrgelds of the Scanian law accord well with the Norse Wehrgelds, for in that case the Wehrgeld of the bonde is 15 marks of silver in both laws. And further, the Wehrgeld of the libertus of the Scanian law and that of the Norse Læsing, after he had made his freedom's ale, also correspond, being half that of the bonde. It may further be noted that as in the Norse law, so also in the Scanian law, the payment for an eye or hand or foot was half a manbot, while the full manbot was payable if both eyes or hands or feet were destroyed. 6. Scanian and Lombardic custom compared. Before closing this very imperfect chapter on the Scandinavian laws, it may be well to compare them with clauses from the Lombardic laws relating to the family holding of land and property in communione. The laws of the tribes still remaining on the Baltic were 5 or 6 centuries later in date than the laws of the Lombardic emigrants who had left their old home and settled in the south upon Roman ground. And yet, in this matter, we find traces of the same ancient custom of family holdings underlying them both, notwithstanding wide separation, and what is more, of the same process of change going on notwithstanding the difference in date. Roman and Christian influences had not reached the Scanian district on the Baltic till the 12th century, and were only then effecting changes which in the 7th century had already been accomplished in Transylvania and Italy. The first clause to which reference may be made is section 153 of the Edict of Rothar, Anno Domini 643. It is entitled De Gradibus Cognationum. It is interesting as showing that 7 generations were necessary to the complete kindred. Quote, Omnis parentila usque in septimum geniculum nomeretur, ut parens parenti per gradum et parentilam heres succedat, sic tanam ut ille qui succedere vult nominatione, uniquique nomina parentum antecessorum suorum dicat, that every parentilla up to the 7th knee be named, so that parent to parent by grade and parentilla the heir may succeed, so moreover that he who wishes to succeed must tell name by name the names of his antecedent parentes. End quote. 7 generations would reach back to the great-grandfather's great-grandfather, an important limit of kindred both in the Norse laws and those of the Cymric. Another clause of the same edict Chapter 167, under the heading De Fratres, qui in casam communem romanserent, enacts as follows, quote, Si fratres post mortem patris in casa commune romanserent, et unus ex ipsis in obsequium regis aut judicis aliquas res adquesiverit, habeat sibi in antea absque portionem fratrum, et qui foras in exercitum adquisiverit commune sit fratribus quod in casa demiserit, et si quis in suprascriptis fratribus gaeretix fecerit, habeat in antea qui factum fuerit. If brothers shall have remained in the common home after the father's death, and one of them shall have acquired some property in service of the king or judge, let him henceforth have it for himself without the brothers sharing in it. And if one shall have acquired anything abroad in the army, let that be in common to the brothers, which he left behind in the home. And if any one of the said brothers makes a donation, let him to whom it was made have it henceforth. End quote. The rest of the clause refers to payments to a wife brought into the family holding by a brother. The meta, or portion, has in this case been given to her on marriage out of the common property, and so the rights of the other brothers have to be considered. Quote, Et qui ex ipsis uxorum duxerit, edique rebus communis meta data fuerit, quando alteri idem uxorum tolere contigerit, aut quando ad divisionem faciandam venerit. Simile modo de communis rebus ei refundator aliud tantum quantum frater in meta dedit, de paterna autem vel materna substantia quod relicum fuerit inter se equaliter dividant. And he who of them marries a wife and her meta was given from the common property, whenever it happens to another likewise to take a wife, or whenever it comes to a division being made in the same way, there shall be refunded to him from the common property as much as the brother gave in meta. But whatever is left of the paternal or maternal substance, let them divide among them equally. End quote. Attempts to settle such questions as these, whether and how far property acquired by one's brother is to form part of the common family property, or be retained by the brother acquiring it, and again how the fact that the payment for a wife's meta had been taken from the common family property was to affect the rights of the brothers when they came to a division, are in themselves good proof, so far as they go, of the continuance of family holdings. But the changes made by these clauses show the same tendency which we've seen in the Scanian laws towards individual ownership and the breaking up of the family holdings. Finally, the point which in the Scanian laws was most suggestive of the original completeness of the family community of property, videlicet, that originally there was no succession of sons to their father's share, but division per capita between the uncles on the grandfather's death, appears again in the Lombardic laws and is dealt with in the 7th century practically in the same way as in Scania it was dealt with centuries later. From the tribal point of view, the solidarity of the family group was the chief interest regarded, but the point of view was changed. Under the new influences, the interests of the individual came more and more into prominence. It now seemed unjust to the sons that their father's property should be allowed simply to lapse into the common stock of the family till the grandfather's death, and then left to be divided among the uncles. And to mitigate the injustice, the right to succeed was given, in the Lombardic as in the Scanian laws, to the limited extent that upon the grandfather's death the sons took the share of their father, with the uncles in the division, as if he'd been living at the time. Section 5 of the Leges a Grimoaldo Addite is headed De Successione Nepotum, qui post mortem patris in sino avi remanserint, and is as follows, quote, Si quis habuerit filios legitimus unum aut plures, et contigerit unum ex filiis viventi patre mori, et reliquerit filios legitimus unum aut plures, et contigerit avo mori, talam partem percipiat de substantia avi sui, una cum patruis suis, qualem pater eorum inter fratribus suis perceptorus erat si vivus fuiset, similiter et si filias legitimas unum aut plures, aut filii naturalis unum aut plures, fuerint habeant legem suam, sicut in hoc edictum legitur, quia inhumanum et impium nobis videtur, ut pro tali causa exheridentur filii ab hereditatem patris sui proc eo, quod pater eorum in sinu avi mortuus est, sed ex omnibus ut supra aequalum cum patruis suis in locum patris post mortem avi percipiant potionem. If any one shall have legitimate sons, one or more, and it happens that one of the sons dies, the father being living, and he leaves legitimate sons, one or more, and it happens that the grandfather dies, let him, the son, take such part of the substance of his grandfather together with his uncles, as their father, if he had been alive, would have taken among his brothers. Likewise also if there were legitimate daughters, one or more, or natural sons, one or more, let them have their rights as is decreed in this edict, because it seems to us inhuman and impious that for such a cause sons should be disinherited from the inheritance of their father, because their father died in the mund of their grandfather. But let them take an equal portion with their uncles of everything in the place of their father." End quote. The continued existence of community in the family property is shown by the fact that even after the concession made in this clause, during the grandfather's lifetime, everything fell into the common stock, and not till a family redivision was made after the grandfather's death was the new rule admitting the sons' succession, along with their uncles, to take effect. To trace further the survivals of tribal custom in the Lombardic laws would lead us too far afield. The clauses already quoted are sufficient to show a remarkable similarity of custom in the case of tribes once neighbors on the Baltic, notwithstanding that they had been widely separated, and that there was an interval of 5 or 6 centuries between the dates of their laws. End of section 22, read by Sandra, near Montreal, 2024.